The turmoil in the public procurement space in South Africa started 16th of February with the Constitutional Court's decision that to dismiss the appeal by the Minister of Finance to the decision by the Supreme Court of Appeal to declare the Preferential Procurement Regulations 2017 invalid. So that appeal was dismissed. It took National Treasury a bit by surprise. They did not give direction in terms of the time frame, and also basically said that the minister does not have the power to develop regulations. It was neither necessary nor expedient. 8 business days later, on the evening of the 25th of February, National Treasury issued an correspondence, which they're now terming an advisory, basically saying that any tenders that you did advertise before the 16th of February, you be finalized in terms of the Preferential Procurement Regulations. Those tenders that you advertised after 16th February be held in abeyance, and no new tenders be issued. That's what they said, 25th of February. Different organizations took a different approach to that. And then this morning, on the 3rd of March, National Treasury issued an advisory note. And briefly, the advisory note just referred to the communication of the 25th, just saying that this was required because they were approaching the Constitutional Court to try and understand the suspension period and whether that will apply, and said that the communication that they put out was really an advisory communication in response to numerous requests for guidance, and further gave some more, I'm not sure if it would be clarity, but they further said that the advice applies also to quotations that are above 30,000, and anything less than 30,000 would be excluded. We'll have a discussion on this statement a little bit later. Section 3 went on to say that organs of state must determine a preferential procurement policy. They refer to Section 2172 of the Constitution and Section 2 of the Preferential Procurement Policy Framework Act. The word determine is an interesting one here. Some would take encouragement in the fact that they're still saying that. The policy and procurement decisions must be made by an accounting officer authority in line with the framework set out in Section 2 of the PPPFA and other applicable legislation. And then they point out that the Act requires that the threshold amounts and the formula must be prescribed by regulation. So although the Constitutional Court said that the Minister of Finance, it's neither necessary nor expedient for the Minister of Finance to issue regulations, there is indeed a requirement in the Act to state the threshold amounts and the formula, and those need to be issued by way of regulation. 5 then went on to provide some really interesting clarity on the way forward. And basically, Treasury is saying that they are in the process of preparing new draft regulations. In a briefing session by the Minister earlier this week, the Minister was talking about instructions. It gives, I guess, some clarity that it is regulations because the instructions wouldn't work. And they are aiming to have them published for comment in the week of the 7th of March 2022. The draft regulations will provide for amounts and the formula that must be prescribed in Section 2, 1B and C of the Act. We'll look at that shortly. 6 then went on, and that's the purpose of today's discussion, to say that an organ of state may, in terms of Section 3 of the Preferential Procurement Policy Framework Act, request an exemption from the provisions of the Act for a specific procurement or category of procurement requirements. Such requests should be limited to the procurement requirements that cannot await the regulations of the Constitutional Court's guidance. and then told us that these papers that they are urgently busy with are being finalized and will be filed at the Constitutional Court as soon as they can. By way of introduction, let's just briefly look at two sections of the Preferential Procurement Policy Framework Act. This is the Act of 2000, which outlines the framework, and you'll see in the Act of 2000, Section 21B1 refers to a prescribed amount for the 10 points, and 21B2 talks about the prescribed amount for the 20 points that may be allocated for specific goals and contemplated, provide that lowest acceptable tenders scores 80 points for price. So basically saying that the amounts must be prescribed, and then went on further to say that the formula must also be prescribed. So that's 21B and C of the Act, the Framework Act. Section 3 of the Framework Act is what we're talking about today. And it's titled Exemption, and it says the minister may, on request, exempt an organ of state from any or all of the provisions of this Act if it is in the interest of national security, the likely tenderers are international suppliers, or it is in the public interest. And so if you go back to 6 in the advisory note sent out this morning, an organ of state may, in terms of Section 3C of the Act, request an exemption for the provisions of the Act for a specific procurement or category of procurement requirements. 3C, talking about public interest. 3C. So the discussion is not around A or B. Today it's around 3C. Here are the suggested discussion points. What might the possible time frame be that an exemption might be required for? Some already on the lines this morning is saying, hey, no problem, next week we'll know and we'll be able to continue then as soon as the regulation is published next week. It's important we understand what the potential effective date might be for new preferential procurement regulations, or what it might be for the Constitutional Court to clarify the suspension period. So that's the first discussion point I'm suggesting. I'm open to suggestions on these points. The scope of the request for exemption. So is it just going to be the prescribed amount and the formula, or is it the entire section 21B and 21C, or are there other exemptions that we also want to potentially look at? When we talk about public interest, how are we going to describe why it is in the interest of the public, why it is in public interest that we're making this request? And then just to see if there is interest to actually participate in a joint request through, and we can talk then about the next steps as far as that's concerned.